Okay, Senator Booker versus Judge Barrett on race. You're not going to believe this exchange is really revealing about what the judge and Supreme Court nominee really
I
thinks.
think you and I referenced this in our private conversation, which I appreciate. Um, you said you were familiar with a lot of the data about the discrimination within our criminal justice system. For example, the U.S. Sentencing Commission shows that prosecutors are more, this is the U.S. Sentencing Commission said that prosecutors are more likely to charge black defendants with offenses that carry harsh mandatory minimum sentences than similarly situated whites. Are you familiar with that, the U.S. Sentencing Commission?
I'm not familiar with that particular.
Does that surprise you?
Um, I mean, I don't know, Senator Booker, that seems an odd thing for me to express an opinion out. As you,
I'm not asking you, these are facts. These are just facts.
And as you and I am not familiar with that study, as you and I discussed, I am aware that there is evidence and that there have been studies of systemic racism or implicit bias in the justice system. So I am aware of that issue. I was not aware.
You're aware of evidence that there is implicit racial bias?
I am aware that there have been studies showing that implicit bias is present in many contexts, including in the criminal justice system.
Okay. I'm just going to read some of these other statistics because I think they're really important, and this is independent data from the U.S. Sentencing.
Okay,
Strike sentencing.
why are they
It's been at a significant higher rate.
censoring him?
Average added 10 years to sentences. You're not familiar with that study?
I'm not familiar with that study.
Do such cases come before the Seventh Circuit?
The three strikes cases?
Yes.
Are you talking about the three strikes, the Prison Litigation Reform Act cases where they're struck out, or are you talking about?
I'm asking cases in the criminal justice system that relate to racial bias. Do they come before the court?
So certainly we have discrimination cases. Certainly there are 1983 cases or Title VII cases.
I would imagine so. And in your research for those cases, you familiarize yourself with a lot of the data on the discrimination within the system?
We familiarize ourselves with the arguments the parties make and the information that they put in the record. And in some cases, I have had parties submit, or it's submitted in the district court technically and then made part of the record.
And so I just want to be clear. Do you believe that there is, in fact, implicit racial bias in the criminal justice system?
Well,
Which is just a yes or no question. Do you believe, in fact, that there is implicit racial bias in the criminal justice system?
Senator, it would be hard to imagine a criminal justice system as big as ours, not having any implicit bias in it.
So is that a yes?
Senator, yes, I think that in our large criminal justice system, it would be inconceivable that there wasn't some implicit bias.
Okay. Over the last 2 years, about 121 of President Trump's judicial nominees to the federal court have said unequivocally that there is implicit racial bias within the justice system. Quite clearly. I'd like to turn to an opinion you wrote last year about race discrimination, Smith versus Illinois Department of Transportation. The case involved an African-American traffic patrol officer who had been fired from the Illinois Department of Transportation. This employee claimed that he had been subjected to hostile work environment and that the supervisor called him the N-word. But you ruled that the employee had failed to make the case that he had been fired in retaliation for his complaints about race discrimination. And now you acknowledged that, quote, and I'm going to quote you now, the N-word is an egregious racial epithet, but you went on to insist that the employee couldn't, quote, win simply by proving that the N-word was uttered at them, and that he failed to show that his supervisor's use of the N-word against him, quote, altered the conditions of his employment and created a hostile or abusive working environment. And you said that even based on his own subjective experience, this black employee had, quote, no evidence that his supervisors were lashing out at him because he was black. I'm very surprised to have to make this point at all, but even a staunch conservative like Justice Kavanaugh, in my questioning of him, spoke to the obvious harm here in a way that you don't seem to. He wrote in a Court of Appeals case that, quote, being called the N-word by a supervisor suffices by itself to establish a racially hostile work environment.
Thank you.
And you disagreed with that. Why do you believe that the law recognizes the harm that is inflicted on a black person in this country when they are called that word by their work supervisor, or by anyone really for that matter, and all the history dredged up in that word centuries of harm, why do you believe differently than Justice Kavanaugh?
Well, Senator Booker, that opinion does not take a position different than Justice Kavanaugh. It expressly and was written very carefully to leave open the possibility that one use of that word would be sufficient to make out a hostile work environment claim. The problem was that in that case, the evidence that the plaintiff had relied on to establish the hostile work environment involved other, he was driving the wrong way down a ramp, and then expletives were used, not the N-word. And the N-word was used after his termination had already begun, and he didn't argue under clear Supreme Court precedent. I didn't make up the objective-subjective element. Under clear Supreme Court precedent, both are required, and he didn't say that it altered the terms of, that's not how he pled or made his case, and it was a unanimous panel decision.
And forgive me if I'm reading this case wrong, but you're saying to me he was not claiming that he had a hostile work environment, and that it is in the fact pattern that this supervisor called him the N-word, and that does not constitute a hostile work environment in the way that Justice Kavanaugh said clearly that it does?
No, Senator, I think you're mischaracterizing what I said, with all respect. In that opinion, the evidence that he introduced to show the hostile work environment was the use of expletives when he drove the wrong way down. He was hired to be a safety driver for the Illinois Department of Transportation, and he based his hostile work environment claim on the use of expletives at him based on poor work performance. That was what he relied upon, and then his termination proceedings had begun. He didn't tie the use of the N-word into the evidence that he introduced for his hostile work environment claim. And so as a panel, we were constrained to decide based on the case the plaintiff had presented before us. So the panel very carefully wrote the opinion to make clear that it was possible for one use of the N-word to be enough to establish a hostile work environment claim if it were pled that way.
I'm going to turn to the AutoZone case you discussed earlier with Senator Feinstein. The initial panel of 3 judges that examined the case ruled against Kevin Stuckey. You were not a part of that initial panel, but you did have an opportunity to vote on whether to hear the case before the entire court. You had an opportunity to affirm the bedrock principle enshrined in Brown versus Board of Education about separate but equal, really to say that separate is inherently unequal. But you voted no. You didn't think the full court needed to examine this deliberate segregation of employees by race. But the judges on the court disagreed with you. In fact, 3 judges explained, we know that, quote, deliberate racial segregation by its very nature has an adverse effect on the people subjected to it. On one of the essential teachings of Brown versus Board of Education, which I know you're familiar with, is that idea of separate being inherently unequal. Why did you think that these separate but equal facilities were lawful, or why didn't you see this as a practice that was worthy of closer scrutiny?
Senator, as I said earlier to Senator Feinstein, I did not make a merits decision on that case, and I wasn't on the initial panel. The calculation of whether to take a case en banc is different than a merits determination, so I wasn't reaching any decision about whether Title VII applied to that situation or not. Federal Rule of Appellate Procedure, I think it's 35, that governs en banc proceedings, sets out standards, and this case didn't create an intra-circuit conflict or an inter-circuit conflict, and so I didn't think it met Federal Rule of, all my vote means is that I didn't feel like it satisfied the elevated high standard for en banc review, not that I thought it was correct. There's a lot of deference to panels in my court.
Right, but I mean, 3 judges disagreed with you, and these were judges appointed by Republican and Democrat presidents. They saw the case about separate and equal really compelling. They thought the issue deserved closer scrutiny, and you had an opportunity to join them, but you didn't. You referred earlier to the problem of implicit racial bias in our system. This idea that...
Wow, that was very revealing. Booker versus Barrett on race. What do you guys think? I think the judge is trying to be very careful not to, again, comment on ongoing litigation. But it appears that for in this particular matters, these were stuff that she actually ruled on. What do you guys think? Comment below.